Anyway, I would like to thank the National Committee on Women to invite me this forum at a time when there is a lot of interest around reforming Muslim personal law reforms, not only within the Muslim community, but also outside with others. I'm also happy about the opportunity given me to take stock of the long-drawn struggles by Muslim women and how political priorities are being set by the state, non-state actors, and diverse interest groups. Especially in the last 5 years, we have seen very stimulating discussions regarding Muslim personal laws. Its content, the procedural lapses, its implementation, which have serious implications for Muslim women who seek justice from the law. We have to remember that the Muslim Marriage and Divorce Act is now almost 65 years. It was enacted in 1951 with some amendments. And we have seen since 2009, the committee appointed by the cabinet with Justice Salim Massouf as the chair, we have seen Muslim women's organizations and groups and also supportive men across the country who have been very vocal about the subject. We know that the issue of reforms is a very complex process. There are competing interests, shifting political priorities, denial of rights, and compromises. So the big question that we confront today is how far have we addressed the ground needs and responded to societal changes, blending new problems and the reality of Muslim women's lives. So I'm trying to recount the contest over Muslim personal law reforms. Firstly, I will talk about why family laws and understanding some confusions about common terms. Then the constitutional provisions and inherent contradictions and parallel systems of laws. I think the expert lawyers will be able to expand on the issues that I'm highlighting. And why we need to reform Muslim personal laws and issues for justice and equality. After that, a brief history of RAF's activism and interventions. And lastly, challenges and traditional arguments to block reforms. So I hope within this time given me, I will give justice to this. Why MPL and why Muslim laws? Because women's situation and status is determined by so many interactive factors. It can be culture, religion, ethnicity, customs, practices, social class, access. I mean it's an endless list. Laws are written and unwritten, because we have the written laws, the legal formulations. But who makes the law is a question. Unwritten laws are the customs, norms, behavior, religion may be used, and whose interpretation is taken. Now, it is the unwritten laws that affect Muslim women more negatively. Of course, it depends on women's position and class and status. Well, I would like to underline 4 critical points here. The plurality of laws, its diversity, because laws are shaped by socio-economic political developments which are always changing. So laws are not fixed. Next, the implementation of laws. It differs from place to place, to context, to country, depends on political regimes. We have enough examples across the Muslim world. Next, laws and its implementation relates to power. Who makes the law? And finally, laws touch every aspect of women's lives, thus their well-being. Now, why do we need to talk about personal laws and family laws? Because personal law is a very sensitive subject. We know that family law regulates the closest ties of men, women, children. It is only family law that has been retained, while other systems of laws have been subject to change. Many countries have retained family law. Why? As it symbolizes an overarching collective Muslim identity. So it is the domain of family where that custom, culture, and law enmesh, and where we can see very clearly patriarchal thoughts and codes are rooted and visible in specific contexts. So this I must say is common to all socio-religious based traditions, which includes traditional Muslim jurisprudence. Now, the schools of thought, there is, I think some of you may know, some may not, that we have four main Sunni schools of thought. Fiqh, which formed through allegiance to legal scholars, the jurists, the Hanafi, Hanbali, Maliki, Shafi. And all those scholars had no intention to make their views final and binding on all Muslims, but to look at the Holy Quran and traditions of the Holy Prophet, to question, to examine, and trust their own reasoning. So personal laws have varied history according to the different schools of laws. Now, one example which I can just mention, there is this whole spectrum. On one end is the Tunisian family code, which is Maliki, has banned polygamy and men's right to unilateral divorce. And at the end of the spectrum, the direct application of the medieval Hanbali law, as in Saudi Arabia, where polygamy is allowed. In between is the middle ground, where polygamy is conditional upon formal permission on specific grounds. But all these use the same verse from the Holy Quran. So in Sri Lanka, we have minimal regulation and enforcement is weak, as registration and non-registration does not make the marriage valid or invalid. So this is a problem. And now when we take kaikuli, the bride price, is not common at all in any Muslim jurisprudence. But it has been taken into account in Sri Lanka. It has been a customary practice that is legally recognized. So I'm again trying to emphasize the diversity. And then when we go into this Sharia and fiqh, also there are multiple positions and opinions. Sharia is the path or the road leading the water. That means the highway good of life, religious values, justice, kindness, common good, wisdom. Whereas fiqh is human interpretation, reasoning, and rules regarding human transaction and interpretation of the Sharia. So we have to understand also that family law is man-made and changeable in the light of changing social conditions. So today, Muslim women's movements across the Muslim world are basing their work on legal reform, trying to address mainly religion, rights, and reality of women's lives. So the other confusion is Muslim and Islam. There is no such thing as a uniform Muslim world and not a unique Islamic law applied everywhere. Because Muslim women in Muslim societies lead very different lives, suffer different degrees of oppression, and also enjoy some different rights. So Islam is a faith, and Muslims are people who practice their faith. So, however, the cultural articulation of patriarchy has its impact, how Islam has been absorbed in different ways in different societies. I mean, that is the point that I want to say. So we need to be clear that what is Islamic history and the history of the Muslim people. So next, I would like to just quickly go into the overarching macro legal framework, the political context, because because I think we need to have the political context, because we are living today in a fragmented, divisive society on ethnic lines. The dominant identity is ethno-religious majoritarianism, and we have the reactive minoritarianisms that are quite pervasive. There is growing influence of identity-based politics, where ethnicity and religion have merged. This is not unique only to Sri Lanka and South Asia, but it's a global phenomenon. And we are living with more than 30 years of neoliberalization. That has resulted in social exclusion, deprivation, inequality, poverty, and gender bias. So patriarchal value system also remains. There are some tinkering here and there, but not substantive systemic changes. Women's activism is growing, organizing at the grassroots. There is some resistance because women are also challenging the system in different ways. Now, when I go to the full citizenship and entitlements, the inherent contradictions, the interface of the parallel systems, the constitutional clauses, I am just pointing on Article 12, the equality, then the restriction, Article 15, then the Article 16, fundamental rights. Then the colonial past and influences also. The codification by the colonialists involved a process of selective interpretation, application leading to distortion and even elimination. Because they recognize, the colonial state, recognized certain social practices which were important for specific social classes and groups. So there is a kind of a mutualing social practices reinforcing the colonial patriarchal interests, violating some of the gender rights, blocking women's rights to access and equality. So the 1806 Mohammedan Code also, I don't want to talk about it later, maybe, how they also, kept polygamy they institutionalized it as an inalienable right of man. So the colonial administrators made the mistake of treating some of the classical texts on Islam as binding legal texts. The next point on this whole thing about the constitutional issues, age of marriage, I think Professor Savitri also mentioned of it, the penal code when the amendments were made, the invoking right to religion and culture arguments that is incompatible with right to equality. I mean, there are some very interesting debates in the parliament by the then Minister of Justice. I don't know whether I have enough time for that, but it's interesting because in the name of protecting the cultural traditions and aspirations of the Muslim community, what he said, right? But the problem is that 16 years is the statutory rate for all citizens. But for Muslim girls, above 12 and below 6 is not statutory rate. So an unregistered marriage is nevertheless considered valid under the Muslim Marriage and Divorce Act. Again, the penal code did not address the offense of rape of Muslim girl below the age of 12. What will be the punishment? So this is a legal anomaly. The other one, which I would also mention, is the converting and reverting, I don't know. Yes, where the man has convert back to his original or faith. And the woman lost maintenance by the board in the name of Sharia, and there is no provision in the law for apostasy. So those are problems. Then, of course, everybody knows about the 88 case of the adoption Gauss for Gauss, where the Supreme Court overturned the rights guaranteed to child under the general adoption ordinance. And actually the precedent was within narrow confines of an outdated tradition without taking into account progressive development in other countries, in Malaysia, which are also Shafi'i followers, which allows adoption, recognizing rights of the adoptee. Though many Muslim scholars see adoption as a meritorial act and not alien to Muslim law as fosterage is allowed. So then let us go to the Muslim issues. Now, since 1986, amongst other things, RAF central focus and pioneering work was Muslim personal law reforms. Its contents, its weaknesses, implementation problems, and see how we can ensure equality and justice for Muslim women marginalized by the system. To mention a few of our activities, we started the mobile legal clinics, that is the Muslim personal law, in 8 outreach areas, trained community-based barefoot legal counselors, initiated dialogues with qazis, judges, board of qazis, JSC, university students, lawyers, politicians, and engaging community groups, women, media, and conducted many issue-based research. Our intervention in the Muslim Personal Law Reforms Committee since 1986, 1992, 2009, and our publications, various public booklets, taking up cases at the Board of Qazis and on appeals, all point to ample evidence to bring reforms in line with societal needs. So, based on this 30 years of work, combining action, research, and activism, the critical issues that we had identified in the area of reform is patriarchal cultural underpinning of laws and its regulation. Because even where religious tenets and interpretations that support women's rights are always overlooked, ignored, or left suspended. Moreover, when state law and custom and religious tenets have different opinions in practice, the least favorable for women is applied. Then the other problem is the legal silence and the formulation of text. Then the interpretation and implementation. Then the procedural lapses, using, especially at the Qazi court. Competence and incompetence of the Qazi judges, because they're varied understanding, lack of understanding, ignorance of the law. And there are a few, one or two are good, I must say. The institution and the justice mechanisms is problematic, because how Qazis are handling, even they are going beyond some of the mandates and bringing their own religious rulings. It is outside the legal system. And ignorance of the Muslim personal law by the enforcing authorities, whether it's police, legal, personnel, mosque authorities, etc. When a woman goes to the police tells them to go to the mosque. And the mosque cannot give legal advice, but they do their own ruling. They give that. So using religion and culture to silence voices. This is the issues that we have identified through our work. And then I would like to move to the activism and RAF's role. I'm just going to skip this a little, because I think what I would want to just say that we started this code of law marriage that was from Batavia, then the Mohammedan code, then the 1929 the ordinance, the 51 the Marriage and Divorce Act. Then we had this commission, the 56, then the 73 is an independent committee. Then we have this 84, 86, I think Professor Savitri will also remember that. Then the 1992 is the Dr. Shabdin, RAFs were there. Then the RAFs facilitated the Independent Committee for Muslim, that is the ICMPLR, and then the latest one, just to give you a glimpse of that. So what do the next one? So what do women want? Consent, signature of the woman, because that is the presumption that majority are Shafis. So they say that there is no space, it's the wali, the guardian will have to sign, but Hanafi women can sign after giving an affidavit to the Qazi. But capacity to marry is, a Muslim can enter into legal binding contracts, buy, sell property in her own name as a legal personality, That is undisputed in Islamic jurisprudence. But in the family domain, that this principle is against the woman. Then the age of marriage, of course, that is still being pushed since the 1973, I don't know, 1984, 86 also the age of marriage would have been touched. That committee also would have touched on the age of marriage, no? No, I'm saying the 80, yeah. Justice Vanasundara also would have. You don't know. I also don't have that, yes. So there's in 73, the Farooq, that was also an independent committee. Then the 1992, Dr. Shavdin's committee, I think Roshani is also here as a member of that committee, representing RAF's interest. I mean, there is enough progressive legislation in many countries. So, I mean, then, of course, the registration, non-registration, that is a problem. So there has to be a punishable offense on this. So that's why the validity. And then the right to be any sect. This was also in the 1990 committee also that was recommended. And to have this eclectic choice, select the best practice and most favorable for women using the traditional arguments. Then restrict unconditional unilateral talaq. Then restrict contract polygamous marriages. Then curtail subsequent. And then the conversion is also there. Again, the landmark case, Reed and attorney. Then on bigamy in the penal code, you know, those. And then the Abe Sundara case. So those are issues that I think even this committee is looking at it. And extend grounds for divorce to add incompatibility. Then recognize the right of unconditional khula initiated by the wife on payment of a monetary, financial compensation. So this is a women's right. She doesn't need to prove fault. And here also, again in 1967, there was this landmark case in Pakistan where you don't need a husband's agreement to go for khula. But in Sri Lanka in 71, the Ansar vs. Mirza case, it was not granted on the grounds of Shafi juris and legal provisions. So the Supreme Court refused that precedent. Anyway, what the reason they gave was that this is not the time for women to ask for khula, and then maybe when that comes, they will. Yeah, there is not a. It's possible, shedding these traditional notions is possibility. But today, more than 45 years since that judgment yet to materialize. In Egypt, in 2000, women's rights campaigned, and the government support and grant women's right to khula. Even the Sheikh Al-Azhar agreed that the right to enshrined in Islam following the Holy Prophet's example. Then the delegated right to divorce is the talaq itafid is there in South Asia, Southeast Asia. This was also suggested by the 1992 committee. That is the women's right to stipulate conditions in the marriage contract. Then maintenance rights, now what we have is only passed from the day of application, but we are asking for interim and past maintenance to recover. Of course, we know that women face a lot of problems in enforcement, claiming maintenance. Then mata is to be extended to swasa. Actually, Raf's case, mata, was won in 2005 in the Board of Qazis. And since then, a lot of mata was given by the Qazis in different areas, even Kalmuna in Putlam, in Badulla, in so many areas. But up to 2014, women were able to get mata. But now it has been stopped. It has been stalled because it is on appeal, and still it's in Court of Appeal. But we are asking for mata to be extended to fasa also, not only for talaq. Then women's right to be appointed in all judicial positions, at Qazi court, board of Qazis, panel of jury as registrars. But in the advisory board in the act, there is no board, there's no mention, there's no bar about sex. And we know that Muslim women can practice as lawyers in the normal court. And then we're also asking for reforms in the system and judicial mechanisms, because there are unfair judgments, lack of knowledge of the law and the social issues and the competence of the Qazis. So I just want to, highlight just three main achievements of RAF. One is the Mata, which I said. Although in our act there is no mention, but we can interpret, because this is a right for women, because it's a progressive Muslim jurisprudence. The other case is the maintenance for the illegitimate child, although I don't want to use the word illegitimate, but the court has used that, setting a precedent in 2014. The other one is the ICMPLR. This is a collective people's initiative which we started in 2005 through wide consultative and a laborious process to highlight the shortcomings and gaps in the Muslim Marriage Act, that it is outdated and does not cater to the present societal needs, and also the reforms of the system itself. This process took 3 years. There are 15 committees, there are 7 men and 8 female. The committee comprises JSC members, Board of Qazis, judges, paralegal counselors, RAF, researchers, and lawyers. Why we needed this? Because we wanted to initiate a reform of a process of reform and dialogue within the Muslim community in the absence of a state-led efforts. Because since 1992, nothing had happened. And also the other thing is to bring our experiential knowledge of the law, social issues, implementation at the grassroots level, and broad-base the law reform efforts with practitioners, lawyers, mosque trustees, Qazi judges, concerned persons, paralegals, and the community women. It was a laborious, intense process because we had 5 steps. Discussions were held in all the respective Qazi jurisdiction areas, includes mosque trustees, general public, lawyers, organizations, and then there was a report. Then the paralegal counsellors and community women affected by the system, they made their report. Then all island Qazi judges forum discussions gave their suggestions, and RAF also with their own experience and interactions with diverse organizations. Then this was collated, structured, and there was a subcommittee prepared the final draft report. Then we invited a body of experts for further discussion, and Justice Masouf was also involved in that process. He gave his recommendations too. And then we had further discussions with intellectuals, social groups, institutions, and all of them contributed immensely to this process. And then the draft was translated into Sinhala and Tamil to reach a wider audience. And then we had a big consultative lobby to discuss the draft with lawyers, Board of Qazis, Qazi judges, researchers, religious leaders, educationists, and in depth we had discussions. We were able to reach consensus, and more suggestions were also added. But of course there were some problems in this. Problems means challenges, which any initiative you have to predict and calculate for those challenges also. So the report was ready. At the time, the new committee was also being appointed, and 4 members of the ICMPLR are already in the members, but one late Jabba who has, left us. But he was one of those live wire. The next thing is, I'm trying to conclude. I don't know whether I'm still on time, and I'm rushing. I think I skipped something. All the time, there is this arguments that come. Time is not right for us to touch anything, Even if all these MPL reforms committees were initiated with very good intentions, the first in 56, then 84, 86, 92, but the political priorities shifted due to many reasons. There was no continuity. In 2005, ICMPLR revived that process, and through our facilitation, pushing and taking up reform issue. The report is to be submitted soon. So that is, again, this time thing. The other thing is the whole Kula judgment, which I mentioned. So that was also, again, not at that time, they said. That was in 71. Then women Qazis also, yes, in 84, 86 also we asked. And then we were pushing again. And they said, we need a fatwa, a religious ruling from Al-Azhar Egypt. We have given the committee the Federal Shariat Court judgment from Pakistan, which we shared with that committee at that time. Then Al-Azhar University since has moved many, many steps in loops. Because in 2006, the Grand Mufti Sheikh Al-Gama said that appointing judges did not violate Sharia. A similar fatwa was issued in 2013. Egypt's current constitution also says in Article 11 that the state guarantees the appointment of women in judicial bodies and authorities without discrimination, and also says there is no legal basis and does not violate Sharia for the exclusion of women for serving. So where are we then? Then, of course, then there will be this thing, backlash and political systems, that the extremists will bring their agenda and there will be this counter reaction. But I think there is conservative forces in all regions, in all religions. And these are mutually reinforcing views. But we need women and men of courage to stand up above these orthodox feudal thinking and clear conscience. We need informed knowledge and commitment to move forward. But I remember that in 1895, during the colonial time, MC Abdul Rahman was able to speak against polygamy. But still, the extremist lobby was able to gain ground. Then the other is has to come from the community. Now, who is the community? Aren't women part of the community? Where are the voices of women from the community? Is it ignored, suppressed, or silenced? Is the last 30 years of work, we have prepared the ground through action, research, mobilization, casework, activism, documentation, facilitating, and preparing the ICMPLR. All these cannot be whitewashed. And what we have achieved is part of our history. The 1992 committee, there were 15 members in that committee, 2 women. Roshan is here. Justice Massouf was co-opted later. More than 100 sittings over 18 months, 24 organizations, include SLMC, sent suggestions. 3 Muslim women's organizations, 7 organizations include RAF, gave evidence with their delegations. All agreed on the suggestions of the reforms, except the issue of women Qazis, as I explained, waiting for the fatwa. Then in 2002, Professor Savitri Gunasekara also will remember, and Kamina was there when we were trying to lobby the UN CEDAW committee. And the state report mentioned that it did not come from the community, and there was not enough consultation from the community. That was the reason they gave. So it means it is that the state did not have the knowledge about the whole process of the whole 1992 MPL reforms and its contents. Then, at the field level, at the grassroots level, according to her record and our limited resources, the number of women who file cases at the Qazi courts, family courts, over the 10 years only, I'm just looking at the 10 years, it has increased. Nearly 10,000 cases were handled by the paralegal counselors in the mobile clinics and the 8 outreach areas. In the same period, we have filed about 900 cases in the Qazi court, Board of Qazis, magistrate and district courts. On average, 50-60% of these cases are on child maintenance and wife maintenance, 10% on return of kaikuli, 15% on mata, others on talaq and fasad. So all these women want justice and have very clearly articulated their problems, and they want reform. So that is do we need any more evidence? Then this is a West agenda. This is somebody's, the assumption that everything bad is coming from outside. We are so perfect, no? But we need a more self-critical perspective, looking inside, and to have a more progressive outlook. We have ample examples from the progressive laws in Muslim countries and communities. And I think we should open spaces for laws based on eclectic choice. Choose what is best from different schools, traditions, and move away from this narrow interpretation of rights and orthodox rulings, which includes an obsession with sex, not sex. Then against our culture and religion tradition. This is where this understanding of religion, culture, Islam, Muslim, all these, we need to take this in detail. The struggles of Muslim women world over, there is enough evidence that Muslim family personal laws are not divine, because they are based on human interpretation and codification of religious texts. So the obstacles here are not culture or religion per se, but perspectives that privilege particular interpretation based on political interests and power relations in that particular moment. So to conclude, I just have one line by way of conclusion. Legal reforms by itself will not be sufficient to change women's status within the family or give protection for women's rights, because much depends on how law is worded, social relations of the context in which laws operate, power and privileges afforded to religious elites, political elites, and their political influence, and wider efforts and winning public opinion to bring the needed social change. So let us celebrate the variety of Muslim traditions and the rich cultural diversity in Sri Lanka, and develop an understanding and respect for different systems, beliefs, based on the underlying principles of equality and justice. So, with renewed hope that the current Muslim Personal Law Reforms Committee will fulfill our expectations and do justice in word and deed. Thank you.
Knowledge Box, the value-based media network.